Many workers in Ontario will soon learn just how closely their boss is watching them work. New legislation in the province requires most employers to disclose details of their electronic monitoring policies in less than a month, so a few weeks from now. That means you'll know if things like your clicks or page views are being tracked. So joining us with more is employment lawyer Mackenzie Irwin. Good morning.
Good morning. Thanks so much for having me.
First of all, how will this information be disclosed to employees, and what details does it have to contain?
Yeah, so employers in Ontario will have to, by November 10th, 2022, will have to provide their employees with a copy of their electronic monitoring policy. They'll have to provide it to them either by way of email or actually providing them with a physical copy. And the policy is going to have to address how, when, and why they're monitoring their employees in terms of electronic monitoring. So it's going to be a very interesting time in Ontario in November to see what monitoring is actually going on.
It will be fascinating to know the how they are doing it, at least for me anyway. The Act doesn't give employees any new rights around privacy while at work. It only requires that the employer disclose their policy. But how far is an employer legally allowed to go when it comes to this kind of surveillance?
Yeah, so that's the main criticism of this legislation, is that it really doesn't have a lot of teeth. It's not providing employees with any new rights that they didn't already have. It's only about transparency, and it's about forcing employers to be upfront with their workforce about what they are actually monitoring. So in terms of where that line is drawn, it's really not clear at this time. There's general privacy legislation throughout different areas of the country that gives everyone, not just the workplace, privacy rights. There's also a common law right to privacy, but employers are allowed to infringe on that privacy right just when there is a legitimate business purpose and when that intrusion is as minimal as possible to achieve that business purpose. So I think the real important part about this legislation is that once employees know how, when, and why their employers are monitoring them, then they'll be able to push back on some of those instances, and we'll be challenging them to see whether they are truly for a legitimate business purpose and whether they are as minimally invasive as possible.
Yeah, it sounds like there's some fluidity around interpretation of some of those guidelines. What consequences could a worker face if they refuse to be monitored? If they say, I see what you're doing, I don't want to participate in that?
I think we are actually going to see a lot of pushback in terms of employees once they know what monitoring is actually occurring. In terms of what their rights are, so this legislation, again, it doesn't provide you with any additional rights. There's no complaint system provided by this legislation. And employers can, as long as their monitoring is for a legitimate business purpose and it's not overly invasive, they likely can be monitoring you. And so if you refuse, your employer, like at any time, can terminate you as long as they're providing you with proper severance. So these kinds of terminations absolutely would not be a termination with cause, and so you would be entitled to some sort of severance.
It will be fascinating to see and to find out who and how and the why, I guess, when this all comes to light at various companies. Mackenzie Irwin, thanks so much.
Thanks for having me.